Mr. President, just before you continue, three things on timing. One is, I'm afraid we have, after all, got to rise at 4:15 today. To make up that lost quarter of an hour, we'll sit at 10:15 in the morning. And we think in practice we're going to need, between you, to go beyond lunchtime tomorrow. But we absolutely have to finish by 3:30 tomorrow. So perhaps at the end of today's hearing, you can confer between yourselves on working out a precise allocation at that time. I mean, in practice, our experience, I think, is that advocates don't take that long in reply normally. So it may be that that's where the time needs to be shaved off.
My Lord, I'm very grateful for that. And of course, in our supplementary skeleton, we tried to deal with some of the points in advance because of time concerns. So,
and I should say, I have had a chance to read over the short adjournment, and it's, as you say, it does focus on the issue.
I was grateful. So just before I come on to the submissions, which I do hope to be able to make relatively quickly in light of the work that's been done this morning, I do need to address the policies directly. The first is the PRSO policy, which you'll recall is the one that deals with allocation of accommodation and is the one that was specifically mentioned in the Minded 2 letter. And we find that in the supplementary bundle, and it begins on page 5. So for the purposes of confirmation, this policy applies to the scenario in which we're in, which is where an offer of PRSO is made in discharge of the main homelessness duty. We see that at 1.1.2. And then we have key principles set out at 2. 2.1, Council's policy is to make available suitable PRSO accommodation within Waltham Forest wherever reasonably practicable, and then dealing with cases where there's a specific reason to go out of borough, which of course doesn't concern us. 2.3, changes to the local housing market and other factors largely outside the Council's control have made it increasingly difficult to acquire properties for use as PRSO accommodation in the borough and in surrounding areas that meet the standards that are required. The service may therefore require properties in a range of other locations where it appears the supply of units in the borough will not be sufficient for the anticipated demand. Mm-hmm. 2.5 makes the point about affordability. And then under offering PRSOs, 3.2, this is where we see the introduction of the zones A, B and C. Confirmation that zone C is everywhere outside zones A and B. And then 3.3, where it is not reasonably practicable to offer a property in zone A within a reasonable time, having regard to the demand and supply of housing and any cost to the council of maintaining the household in temporary accommodation, a property in Zone B or Zone C may be offered, depending on its suitability for the applicant and his or her household. So there we see the clear distinction between the in-borough duty and the out-of-borough duty. But the reasonable practicability is only made reference to in relation to accommodation within Zone A within borough. There's obviously no reference there to the out-of-borough duty to accommodate in zones B or C as close as possible to the applicant's former home or indeed the borough.
Nor a reference to reasonable time within the second.
Exactly. At 3.6, applicants will be individually assessed prior to any offer to determine the type and location of accommodation that should be offered. The size of property offered will reflect the council housing allocation scheme, etc., although exceptions may be made subject to affordability. An offer of a property with one bedroom less than the applicant's assessed housing need or smaller with the applicant's agreement may be made to minimise costs to the council of providing temporary accommodation and in order to make the best use of available supply. So prompting the very scenario which the appellant in this case sought to engineer. Then 3.8, we see the retaining units provision. The following households will normally be given highest priority for accommodation within or close to the borough, or close to their place of employment, etc. And we see a system of prioritisation for accommodation within or close to the borough, which on any reasonable view can only mean zones A and B. Paragraph 3.12, confirmation. Households that have a relatively low level of need when considering the above circumstances are more likely to be offered accommodation in zones B and C. However, even if a household is considered to have a lower level of need than other applicants to be or in close to the borough, they will be offered available units in zone A or zone B if these units are not required by higher priority households. Perfectly compliant provision, but of course only addressing provision of accommodation or as set out there, distinguishing between A and B and C collectively. And then just 3.13 and 3.14. Before an offer of PRSO accommodation is made, an affordability assessment will be carried out to ensure that the offer is suitable for the household. So before the offer is made, this will take into account local housing allowance levels and the applicant's current and likely future circumstances. So likely future circumstances. 3.14, households in receipt of welfare benefits may be subject to restrictions on the amount of benefit they can receive, which may affect their ability to pay rent. May affect. Offers of accommodation in Waltham Forest or nearby boroughs, again limited to Waltham Forest and nearby, are subject to suitable accommodation being available and the applicant being able to afford accommodation in those areas. The benefit restrictions, brackets cap, make properties in Waltham Forest and London unaffordable. They will not be regarded as suitable. I believe that's all we need to look at on the policy in relation to allocation. And then just looking at the policy on acquisitions or procurement, which begins at page 11. Introduction. Again, here we're looking at PRSO purchases, as 1.1 makes clear. And then 1.3 states the council does not have sufficient units of accommodation within its own owned and managed stock, and as a result we depend on the supply of privately owned properties to meet our obligations to provide accommodation to homeless households. Changes to the local housing market and other factors largely outside the council's control made it increasingly difficult to obtain suitable properties which meet the required standards in the borough or in the surrounding areas. Again, consistent with the allocation policy, that's where the evidence base is about scarcity of supply. Under key principles, bullet point 4, in addressing the shortfall, which has just been identified, the service will endeavour to acquire units in locations which are close to Waltham Forest in order to minimise as far as possible the distance between the borough itself and the location of accommodation being offered to households who cannot be accommodated within the borough. These nearby locations are Zone B. Where the demand for accommodation is such that it is unlikely to be possible to acquire sufficient properties for all homeless households in Waltham Forest and in nearby locations, the service may acquire properties in other locations, Zone C. Under heading 4.0, anticipated demand for accommodation. Given the level of demand, it is certain that the service will not be able to meet the need for accommodation using only properties within the borough. There are also very severe challenges in acquiring properties in nearby locations, most of which are experiencing steeply rising property prices, etc. Again, reference to nearby locations. On this basis, the acquisitions policy assumes that it will be necessary to procure properties in a range of locations beyond the borough itself and nearby locations, i.e. Zone C. All properties procured under the policy will be as close to the borough as is reasonably practicable, given the financial constraints within which the service operates and the practical difficulties which can prevent units being procured in the borough or nearby locations. So there we do see reference to the out-of-borough duty in the context of the procurement policy. And then instructions to suppliers. As the procurement of individual properties is vested in the suppliers and landlords working on the service's behalf, the service must ensure that the supplier's actions are compliant with the acquisitions policy. The decision whether to use a particular property which is being offered by a supplier is made by the service, that's the in-house service, and must be informed by applying the key principles of the acquisition policy. The suppliers who procure accommodation on the service behalf are made aware of the council's requirements and of this policy. 5.4, suppliers are requested to procure as many properties as possible in the borough, to procure properties in nearby locations wherever possible, and to procure properties as close to the borough as possible when considering other areas. And then at 5.5, where it may be possible for suppliers to deliver cost-effective arrangements for accommodation in other areas, managers in the service are authorised to approve these arrangements where it appears clear that, on the basis of trends in supply and demand, etc., zones A and B are unlikely to be enough. Likely there'll be a shortfall in the number of available units located in areas between the borough and nearby areas, and the location of the potential acquisition. The properties in question meet the physical standards set out in the council specification for accommodation, procurement, etc., represent good value for money for the local authority. And then it says what you'd expect, which is that the private rented sector allocations policy is then applied in the process of matching each individual property to the homeless household. And establishing what would obviously be the case, which is the property must ostensibly be suitable on ordinary terms. Then process for acquisitions, paragraphs or heading 6. The process by which individual properties are offered to the service by suppliers is set out in the relevant service specification documents for each type of accommodation procured and in the procedure of the accommodation procurement team. Before agreeing to the use of a specific unit, officers in the service are responsible for ensuring A, that the relevant acquisitions process has been followed, and B, that the acquisition of the unit is consistent with the principles of the acquisitions policy as set out above. Where there are not likely to be sufficient units in the borough and nearby boroughs to meet demand, officers in the service can authorise the acquisition of properties elsewhere in order that it will be possible to meet the service's obligations. So that's the acquisitions policy.
I'm just pausing there. Is there anything wrong with that?
Yes, there is, in the sense of, let me backstep a third. The criticisms of the policy are not that the policy itself is unlawful, the acquisitions policy, but there's no evidence that it was applied lawfully in this case.
Yeah.
Sorry. That's ground 1C. The omission in the policy, or the notable fact of the policy, is nowhere does it say or provide any evidential basis for a proposition, not that that's been made, that there is some problem with supply in Zone C areas that are closer than Stoke, for example, or generally.
At the same time, if the policy had been accurately applied, the result should have been properties closest to the borough.
One would have assumed as much. And there's absolutely no explanation fundamentally as to why that hasn't happened, which is really the essence of the complaint under ground 1C.
Yep.
Before I get to 1C, if I can just go through the other grounds. Most of this, I would hope, as I've said, has really been foreshadowed in the analysis of the law and the documents. What I am going to do, just for your ladyship's and lordship's pen is just give you the relevant skeleton argument paragraph numbers, just to avoid any potential confusion. So ground 1A is addressed in the appeal skeleton, paragraphs 21 to 33, and the supplementary skeleton, paragraphs 4 and 5. And in essence, it can be distilled down to this, that the PRSO allocation policy does not apply the out-of-borough duty explicitly anywhere. Nowhere does it say, if it's not reasonably practicable to provide accommodation in borough, and you are considering accommodation in zones B or C, you must provide accommodation as close as possible to the applicant's former home. You would expect to see that if it was a feature of the policy in its key principles, and perhaps you'd expect to see it in paragraph 3.3, which is the paragraph which says in terms that if you can't accommodate in borough, then you can go to B and C. The consequence of that is there's no onus on a temporary accommodation reduction project officer, as she's described, Miss Uduezue, to ensure that she offers the closest property available in Zone C, or indeed in B, and on any view that is a major omission in the policy, it doesn't comply with the law. Obviously, in this case, we're concerned with an offer made in Zone C. And what we do have in paragraph 3.8 of the policy is a system for prioritising accommodation between households in Zone B. But nowhere does the policy say anything about Zone C at all.
Does this take you anywhere unless you can get somewhere with one of the other grounds? You're obviously ahead of me in the sense of it's all right just to look at what's available on the day. It really doesn't matter what the allocations policy says because that was all that was available.
I absolutely agree, and that is why the other grounds are important. But it's also important to understand this feature of the scheme. One, because this court may wish to say something about that in due course, because of course it's important, and in another case it could be very relevant, not only in this borough, indeed in other boroughs, we've seen other boroughs use similar zonings. But also because the fact that this is the case, we say, has had material impact on other aspects of the decision-making process in this case. And I'll come on to make that good in due course. But it's right to say that if there's only one property to be considered, and there's no allocation, in fact, to be undertaken, then it doesn't really matter whether or not you need to find the closest one, there is only one. One of the reasons why we say it's material is the reviewing officer doesn't seem to appreciate anywhere in her decision that once you're looking at somebody who's been deemed eligible for Zone C, you must secure accommodation as close as possible within Zone C. Had she appreciated that, you might have expected her to query why there was nothing available in Zone C, particularly because the procurement policy doesn't anywhere say there are any problems acquiring properties in Zone C. What we do know is that later in March 2022, she does make an inquiry of the head of the procurement team and ask questions about whether or not the procurement team look in Zone B. It doesn't elicit any information that helps us understand why no accommodation was otherwise available in Zone C. Accepting, however, that for current purposes, you only need to look on one day, accepting for current purposes there was only one property available on the 22nd of July, we move on to the reasonable time point. This is the only one that gets a bit complicated on the references in the skeletons. So it's raised squarely in paragraph 27A of the appeal skeleton as one of two arguments that are raised in relation to ground 1A, the other one being the one we've just looked at. They are, of course, closely related. And it's addressed further in the supplementary skeleton at paragraph 5. what we say is, rationally and logically, in principle, looking for a reasonable period of time is going to be relevant to discharging the obligation in relation to reasonable practicability, or indeed where possible. If one to ask the question from an open starting point, in order for a local authority to demonstrate it's not reasonably practicable to provide accommodation in borough, or it's not possible to provide accommodation any closer than somewhere like Stoke, the logical answer would be, well, for what period of time were you looking? And whilst it's true to say there's no case law which says you cannot only look for a day in terms, it would be surprising if the law was such that you could restrict yourself to a single day and still pass the reasonable practicability threshold in every scenario. Which is why we say, in essence, that Lord Justice Lewison in Alakabet doesn't confirm that one day is enough. On the contrary, he says it may well not be enough. And it all depends on the particular facts relevant to the location that you're in. We say that means in principle we're right, that it is a rational and logical component of reasonable practicability, or where possible, whichever expression you use, to consider time and how long you might wish to look for. Now, the respondent doesn't deal explicitly with the contention about whether or not you ought to have a reasonable time. It doesn't address, for example, why its own policy at 3.3 appears to treat the in-borough duty and the out-of-borough duty differently in that regard. So we don't have a response to that. What my learned friend does say is effectively, well, this point's already been addressed, as I say, in Alakabet. Apologies. And for the reasons that we set out in the supplementary skeleton in paragraphs 8 to 12, we say that's not the case. Not only did Lord Justice Lewison accept in principle that waiting a bit longer might be a relevant consideration, the reasons he gave as to why it wasn't a relevant consideration in that case do not carry over to this case, because there is no evidence of a shortage of supply in Zone C. Whereas in Alakabet, there was a very severe shortage of supply in Westminster. Waiting would have served no purpose. The same has not been said in this case, and there is no evidence that there is any shortage of supply in Zone C.
I do have in mind that we were on territory near this in the Broderick case. I don't properly remember what we said about the Broderick case.
Yes, so...
Sorry, my lord, it did surprise me that that didn't find its way into vulnerable authorities, and that's probably my fault. But I was reading Broderick over the weekend, and you were very close to... You effectively affirmed that Alib-Kiet... Broderick is before Alib-Kiet, but it's effectively the same.
I think
it's just after. No, it's just after, I apologise. And
it's dealt with in Al-Qadir. I take the view that nothing said in that case, which I have read, has any impact on the appellant's submissions, but of course I'll address that if my learned friend wishes to rely on that case.
I don't remember it well enough to know whether it might or might not.
Well, there it was a slightly different question, or at least the issue was put a slightly different way, which is whether or not you could challenge independently a decision to discharge duty on a particular day. Whereas what we're really saying here is, as part of the obligation to ensure wherever possible you accommodate as close to the person's previous home as you can, by definition that must import a consideration of time, which is how it was put by Mr. Manning in Alakabet. And indeed, the inconsistency is there on its face in paragraph 3.3 of the PRSO policy. Why does it make logical sense to apply it to the in-borough duty and not then to apply it to the out-of-borough duty? If anything, it's much more likely to be relevant in relation to the out-of-borough duty, because you're not then dealing with highly pressured London local authorities, where just like in Westminster, it's probably the case that not much is going to change over a short period of time, unless some unique situation is developing, like a new set of flats that the local authority happens to know is coming online soon. But in a general scenario, when you're looking at all of Zone C, and there's no evidence that there are any pressures on the Midlands areas that are the focus here, it seems, in the appellant's submission, perfectly rational to say, well, let's just wait a bit and see if we can get anywhere closer than 175 miles away.
But are there parameters in relation to that? I mean, reasonable is reasonable, but presumably you're thinking that there would be a time frame, a reasonable time frame for such a search, and what would that be?
Well, we would accept that ultimately that would be, as every component of the reasonable practicability test or the other possible test, is it's ultimately for the local authority to determine having regard to substantive evidence. Now, what we know in this case is that there was one property available in Zone C on a particular day. There wasn't anything available in Zone C on another day. We have to accept that. But there is variation in the sense that properties in Zone B, which are 2-bed, are coming up repeatedly, for example. So it's one feature, we say, of the local authority's failure to demonstrate compliance with the overarching duty to ensure they accommodate as close as possible to the appellant's former home. There isn't any other explanation as to why the property has to be offered, or the search, I should say, has to be restricted to a single day in the same way as there was in Al-Kabet. And we summarise our reasons for saying that in paragraph 12 of the supplementary skeleton argument. The second feature of why this was a particular consideration, or ought to have been a particular consideration in this case, is because, of course, the local authority had accepted the 193 duty in relation to the appellant in October 2020. They'd had months to find somewhere. They warned her right at the outset that she was very unlikely to get social housing and that she was likely to be made an offer at PRSO. Absolutely no explanation as to why, during that period of time, a search couldn't have been carried out. There was nothing urgent about it. The local authority were happy for her to stay where she was, accruing rent arrears, etc. So the combination of those two reasons, the fact that there isn't any evidence that the pools of supply that would otherwise be available in Zone C were significantly pressurised in terms of availability, the fact that other accommodation is clearly coming up in Zone B, including 2-bedroom property, and the fact that the respondent hadn't done anything for many months after accepting the duty, all of which point to reasonable time being a relevant consideration to the discharge of the obligation. So ground 1B is about the assessment of affordability and 3-bed as opposed to 2-bed. I suspect you essentially have this argument through the course of the submissions this morning, but it's found in the main skeleton paragraphs 34 to 38, the supplementary skeleton paragraphs 6 to 12. The 2 points really to note are that the appellant herself had raised this in August, page 161, supplementary bundle, and paragraph 3.6 of the PRSO policy specifically makes provision for that possibility. It's abundantly clear when you look at the review decision and the witness statement in the round, the local authority never asked itself the question, well, what if she was to accept a 2-bed accommodation? What might that mean for affordability and the range of properties that would be available to her?
Can I just understand the time frame on this? The offer is made, I can't remember what date. Miss Zaman expresses her willingness to take a 2-bed property later.
Before the review is concluded.
Before the review is concluded, but where an offer has been turned down, you look at the position at the date of the offer.
You do.
In which case, does it matter that she subsequently said she'd take a 2-bed property?
Absolutely, because she's there demonstrating her willingness to do that. The policy itself says consider it, and nowhere is it considered. I mean, I'm not demonstrating that as the trigger. I mean, it's obviously relevant. But what the local authority should have done is say, well, what are the possibilities if we accept a smaller property, as the policy itself dictates, keeping in mind that otherwise this is somebody who's going 175 miles away.
Okay. Do you mean they should have considered that regardless of her expressing the willingness to take the two-bed property? Or do you mean that although she hadn't expressed that willingness until after the offer had been made, I can't remember, had the local authority yet said it was discharging its duty?
So the way the process works is on the 22nd of July 2021, when they make the offer, they're saying this is in purported discharge of our duty, and it's a 3-bedroom property. She then refuses that and seeks a review, and in the course of that process says, but I would take a 2-bedroom property. So what we would say is at the stage where they're considering what to look for this particular applicant in this household, applying their own PRSO policy, they would say, well, okay, what are the options if she was to move down a bedroom to a 2-bed?
But that doesn't depend on what she said.
No, it doesn't depend on what she said.
So what she said falls out of account here. As a matter of general policy, where you have someone with this number of children, you should be asking yourself.
Yeah, I take it's more of a forensic point. I appreciate that. It's me making good something that would otherwise look like a clever barrister's point on the face of the policy. By which I mean I'm trying to explain that this was a real issue for her, and had they asked her beforehand or considered this issue, she would be likely to be compliant. And we have evidence from that. I'm not saying that the consideration of 2-bed was dependent upon her raising it unilaterally herself.
So, turning it round,
yeah,
it's something that the local authority has to consider before making an offer in relation to anyone, where the normal allocations policy would say there should be a larger property, but you wouldn't infringe overcrowding considerations if there were a smaller one.
Yeah, yes, absolutely. Particularly where you're in a scenario where you're looking to be otherwise providing accommodation many hundreds of miles away. I mean, it might be less relevant if you're not in that scenario. Again, it's all part of this overarching obligation to ensure wherever possible you can provide suitable accommodation. Now, the policy itself says a property which is 1 bedroom short implicitly might be suitable, and it might mean we can provide something nearer. So why wasn't it considered in relation to this particular individual?
So what do you do? You
on the 21st of July, when you speak, sorry.
On the 21st of July,
yeah.
We're dealing with this particular applicant.
Yeah.
There are lots of applicants around, lots of people who have claims on the local authority. On a particular day, they're looking at what to do, thinking about whether to make an offer.
Yeah.
They have someone who, on the face of it, merits a 3-bedroom property. What do they do?
Well, in the conversation and the assessment that's carried out on the 21st of July, the officer should say to the individual, okay, look, 3-bedroom properties, you can't afford these. You're going to be 175 miles away. Our policy says I can offer you a smaller property and it might be nearer. What's your response to that? I mean, otherwise the provision in the policy is somewhat pointless, because is it incumbent upon the individual themselves to highlight that issue in time to trigger that issue? I mean, realistically, this all has to be done before an offer is made. Is an applicant really going to know that that possibility is available unless it's made known to them?
What happens, I mean, suppose you do accept the offer, regarding it as unsuitable, but nevertheless accept it, and then say, look, I'm happy to take a 2-bed property instead.
Yeah.
That could then be taken into account on the review.
Absolutely, yeah. Absolutely. It would have to be taken into account.
It would have to be taken into account. So in that scenario, everybody's better informed than...
yeah.
Yes.
I mean, the policy either makes provision for this or it doesn't. And if it does, then it's got to be something which is applied by the officer when making the assessment as to where the person is likely to go. And keeping in mind that the objective of all of this policy, as articulated in the guidance and the order, is to try and ensure people aren't sent hundreds of miles away. And you've got a provision in your policy which might allow for some flexibility in that regard. To not consider it when making an offer is a relevant illegality, we say. I'm sorry I didn't make that quite clear enough when I was referring to what she subsequently says on the 2nd of August, but that was to make good the proposition that this was material from her perspective.
Yeah.
The only other point that's relevant to this is the statement by the reviewing officer at paragraph 33, which is the statement you may recall where she says, well, even in Essex, a 2-bedroom property would have been unaffordable by reference to the local housing allowance. I made my observation about that earlier, which is about whether or not she could offset to some extent. So, my lords, my lady, I then turn to ground 1C, which is about procurement. So if you're against me on the materiality of ground 1A, which is about the inadequacies of the policy in terms of the out-of-borough duty in the PRSO policy, and are against me on grounds 1B in relation to the relevance of a 2-bed property and the PRSO policy, we still say in any event there's a clear failure to demonstrate compliance with the out-of-borough duty. And that is the case whether or not you look at the policy itself, the review decision, or the evidence that has subsequently come to light. There is essentially just no evidence or explanation as to why nothing was available in Zone C that was closer than Stoke, or indeed that the respondent complied with its own procurement policy. You'll have well in mind the comments of Lord Justice Lewison in Al-Kabet and indeed in Al-Qadir about the relevance of policies. They are one means by which the local authority may discharge the positive obligation, and in principle, if there's a lawful policy which has been applied, that may be sufficient to demonstrate the individual decision is lawful. Of course, the acquisitions policy in this case does say, materially at 4.3 and 5.4, that all properties procured under this policy will be as close to the borough as is reasonably practicable. And indeed, specifically, that suppliers at 5.4 are requested to procure as many properties as possible in the borough, to procure properties in nearby locations wherever possible, and to procure properties as close to the borough as possible when considering other areas. So all of that is acknowledged and accepted. However, what the policy doesn't do is provide any evidential basis for the apparent lack of any accommodation in Zone C that is closer than Stoke. Shortages are identified in London and nearby areas. They're not identified in, for example, the Midland areas or anywhere else in Zone C. We say, therefore, there is no evidence that there is any such shortage in those areas. Therefore, it just begs the question, why hasn't accommodation closer than Stoke been identified? The policy is entirely non-specific about where in Zone C accommodation is sought. Reference is just made to other areas. It's very open considering the size of Zone C. And as is set out in the supplementary skeleton at paragraph 14, the respondent plays a seemingly very passive role, waiting to be told what's available by its suppliers. Nothing is said about the locational reach of those suppliers. We know nothing about whether or not they have suppliers who deal with the Midlands area, and if they do, why they didn't produce any properties, and if they don't, why they don't have them. But the policy is one thing. What do we see in terms of evidence of its application? Well, as I hope I demonstrated earlier, even though the point was explicitly taken up by Camden Law Centre, and as I highlighted in relation to Ground 1A, the reviewing officer just doesn't address this point anywhere. And indeed, in the review decision, she seemed to think she didn't have to address it. We say this is entirely consistent with the PRSO duty, which doesn't require anybody to apply the outer borough duty to Zone C. Moreover, there is no evidence that the local authority did look any closer than Stoke. The best the local authority have got is paragraph 13 of Ms. Batt's statement, but that just confirms that the local authority looked in Zone B. Even if that's wrong, and they did look more broadly at other areas in Zone C, including, for example, the Midlands, there's just no explanation at all why nothing came up across such a large area. Nothing is said in general terms about this, and nothing specific to the offer made to the appellant. They don't say why, having looked in the Midlands, nothing came up, or even indeed they did look in the Midlands and nothing came up, or why they didn't think it was worthwhile looking in the Midlands. There's just nothing in the policy, in the evidence. The other source of material is the Freedom of Information Act. What's said about that is that that demonstrates that accommodation in Zone C is offered that isn't in Stoke. That may be the case, although there's a heavy preponderance for Stoke, about 50% of the properties that are available. We just say that begs more questions than it answers. But in any event, what the FOI information doesn't show is that the local authority is offering accommodation in areas closer than Stoke. We don't know where the other offers are made in Zone C. Ultimately, it's not enough to have a policy. You must be able to demonstrate that it's been followed in a particular case. That's Abdicadir, paragraph 59. And the burden is clearly on the respondent to demonstrate this, even if the point has not been raised. That's 53 to 54 and 56 in Abdicadir. Of course, that's another case where the local authority said there was only one unit of accommodation available, but that was ultimately overturned. Also contrast with Al-Kabet. In that case, the local authority offered accommodation in the next available pool of supply, having demonstrated good reasons as to why there was no accommodation available in London and the South East. And that's paragraph 80. And explains for good measure, in terms, why it could no longer obtain accommodation in areas that were closer.
And now I am becoming very concerned about time.
Grateful, understood. So my final points on this, I'll just be quick, as quick as I can. As it was also raised explicitly on the review, that's giving you the page reference number is page 169, there's no evidence that the local authority complied with its own safeguarding obligation in paragraph 6.0. That's the one where the officer who makes the offer of accommodation checks that the acquisition or the procurement is compliant with the key principles, and indeed, particularly in this context, compliant with the obligation to find accommodation as close as possible. And that's raised explicitly by the Camden Law Centre and mentioned by the reviewing officer at paragraph 127, page 158 of the core bundle, but is nowhere addressed by her in the review decision or indeed in her evidence. So we say, for all those reasons, it's not at all apparent that the local authority have applied their own policy in the context of this particular PRSO offer, or otherwise provided an evidential basis to why no accommodation was available in Zone C that was closer than Stoke. And we point out in the supplementary skeleton, you can read in due course, that there were no particular So just to summarise on where we say all that goes, true it is that you don't know for sure what would have happened had the respondent applied the outer borough duty to Zone C, or if it looked for two-bedroom properties, or indeed anything else closer to Waltham Forest and Stoke, but that's not necessary. If there's some prospect that it might have had a different outcome, then that should be sufficient, and that's again Lord Justice Lewison in Abdicadir at paragraph 58. Applying the Court of Appeal in Ali versus Newey, which is in your bundle of authorities, tab 10, paragraph 13, page 104. So that's a relevant test. My lord, my ladies, on ground two, I think you essentially have the point. Can I just give you some final references on the law in relation to that? There's no doubt at all that the reviewing officer was obliged to consider affordability. That's pursuant to the decision of Cramp versus Hastings, paragraph 14, where it said that matters which are obvious need to be considered even if not raised on the review. The HHJ case, paragraph 44, and indeed in Abgadir itself, paragraph 53, all make it clear that if there's a legal duty to consider something, it must be considered, whether or not raised. And then the case of Paley is a good example of where, even though affordability was raised, so there was no question about it being a relevant consideration, the applicant hadn't challenged any of the figures in the Minded To letter, but the decision was nevertheless overturned. And whilst Lady Justice King recognised that the appellant in that case was on a weaker footing because she hadn't raised particular contestations to the figures, that didn't mean the local authority was free of the obligation to carry out an objective assessment. That's paragraph 72 to 86. And of course, you have my points that the local authority themselves proceeded on the basis that the appellant would have to travel to and from London to visit friends, etc. And no account is taken of that in relation to the financial assessment at all. And again, we would say Ali versus Newham is determinative of what approach this court should take. We don't know what that would have ultimately meant for affordability. It's not for the appellant to adduce evidence to that effect at this stage in the proceedings. It's just a clear failure to consider a relevant matter and therefore vitiates the decision unless it's inevitable that the outcome would have been the same. And on any view, one can't do that with uncosted items of that nature. My lords, my ladies, I'm sorry for taking much longer than I was planning, but unless I can assist further at this stage.
Thank you very much. Mr. Hodgson.
May it please the court. I propose, if the court agrees, to deal with the application to amend at the end.
Yes.
My lord, you'll see that the applicant is a single woman who at the time of the review had 3 children, aged 9, 2 and 4 months, all girls. She was made an offer of a 3-bedroomed out-of-borough property, which she declined for a number of reasons, but for our purposes, 2 most important are distance from Catherine's school, you would have to change school, and distance from her support network. And when I say support network, she makes it clear, I'll take you to her representations, that is practical support, not just contact with friends, helping with school runs and so forth. What is different in this case is that there is no Part 7 policy. There is no private rented sector policy, no procurement policy. There is a Part 6 policy, which we say is really neither here nor there. And what's happened in this case, we say, is that the authority has assessed eligibility for accommodation under the Housing Register, Part 6, but not suitability. What happened, it transpires, is at the date when the 3-bedroom property was offered to her in Chatham, there were in fact 2 other 2-bedroom properties in Borough, which would have been, on the face of it, ideal. She was not told of this until she received the review decision, so she was not in a position to make any representations. And the only reason given of them that can be inferred as to why the 3-bedroom property was offered to her is because she was entitled to a 3-bedroom property under the allocation scheme. So we say that for a single mother with a newborn baby and 2 children the same sex under the age of 10, 2-bedroom property would be perfectly adequate, or it's likely to be perfectly adequate. There may be particular features we don't know about. And in fact, one of the property, 2-bedroom properties, was actually a house. There's no question of overcrowding or anything of that nature, and it would have been ideal for the family. Indeed, if she'd been offered a 2-bedroom property and had turned it down as being unsuitable, there's no question she would have not succeeded in any possible appeal against the review decision. The skeleton arguments refer to the authority, but I don't think there's anything between us, between me and us and my own friend for the authority on that point. And of course, what one needs to bear in mind that this is Part 7 accommodation, it is temporary accommodation, and it's only for 12 months or up to 2 years. I think it's Lady Hell in Arley who drew the distinction between temporary accommodation under Part 7, which by its nature is relatively short term, and it's well known that families frequently have to move from accommodation to accommodation until eventually they're allocated permanent accommodation. Whereas accommodation under Part 6 is very different, and that implies a degree of permanence. And then, of course, you need to consider the children growing up and so forth. So that's the difference, we say, in our case. My only friend in his skeleton argument refers to Cramp and Hastings. We say, well, firstly, it doesn't apply because, as my learned friend, Mr. Burton, took you to, the law is that where there's a duty, the Cramp and Hastings criteria don't apply. But in any event, it's a bit of a nonsense because she couldn't have made any representations on review because she had no idea that there were 2-bedroom units of accommodation available for her. She simply had no idea. So, my lord, my ladies, we say that is a clear failure to secure accommodation in borough so far as reasonably practical. They simply haven't done that. They've chosen to follow the wrong policy, or they didn't have an appropriate policy, and by doing that, they've just not considered the suitability of the smaller units of accommodation. So I propose just to take you to some of the evidence. It's very little, but so you see the steps taken by the officer who makes the offer on the 11th of August, the representations between the parties up until discharge of duty, that's on the 13th of August. The court would go to the supplementary bundle, page 43. This is the file note dated 11th of August, which shows that the offered property was a Chatham property, 3-bedroom house, but at the time there was also a 2-bedroom flat and a 2-bedroom house, both within the Bexley borough, and a 4-bedroom house, which we're not concerned about. And then it said the 2- and 4-bedroom properties would not be deemed as suitable for Mrs. Uduezue due to their size, off of 85 Harrington Street, Chatham, therefore made. And that's really all there is. There's then a income and expenditure sheet, and then at 46 we have what is effectively, as I understand it, a checklist by the reviewing officer, setting out what he's read and confirming his decision. Then at 51, he, as he should do, he checks, makes another check on the date of the review decision. I think there's a typing error. I think it should say, as of today, there are no housing association properties available for bidding. And then at 52, we have what's called the PRS offer record. This is not dated, and we assume that it was prepared after the offer because at the bottom of the page it says medical issues. Applicant advised no long-term medical conditions. However, did advise had a C-section when a baby was born 8 weeks ago at time of offer. So that would suggest this was prepared after the offer was made. And you see, it deals with the composition, employment details, affordability. Schools that have places in Medway.
And these are obviously all primary schools.
Yeah. But nothing about what support the appellant is receiving or requires, or any inquiries whatsoever of the school that Catherine is attending. And the email correspondence dealing with the offers start at page 29. See, it starts with an email from the Housing Resettlement Team, 11th of August 2020. Following our telephone conversation yesterday, please find attached letter confirming that the council is making you a final offer of accommodation. Please ensure you read the letter carefully. Property is a 3-bedroom house, sets out the rent. Then she responds, page 30. I beg your pardon, on page 30 there's more details. And they say the government website advises there are 15 primary schools within a 1-mile radius of the property, 68 primary schools within a 3-mile radius of the property. You then ask for videos of the property because she's still suffering from the C-section. Then on page 34, she sets out her reasons why the offer accommodation is unsuitable. She sets out the medical situation. She's vulnerable. Then she says, I'm unable to sustain my children's needs fully at the moment due to the operation I had. Most help are from friends and family that lives around our present location. Pausing there, she doesn't have family. When she says family, she's referring to fellow churchgoers, the local church. If we are being moved to the offered accommodation, all these support will be cut off. Such a condition will be traumatic for me and the children, and I'm not driving at the moment. My eldest daughter's education, she's preparing for 6+ examinations. Just pausing there, it's accepted, that's an obvious mistake.
I don't know if it is necessarily a mistake. Is it referring to year 6?
Oh.
It doesn't really matter. It's
No,
an 11+
no.
exam in other terms.
Yes.
Yeah.
Yes, I hadn't thought of that. That makes perfect sense. That is forthcoming, and moving that far will be a distraction to her studies, and most especially the bond she had with her friends around her will be cut off. In view of all these, I believe it is not suitable to move me and my children to the offered accommodation due to the far distance. The response, bottom of the page, bottom paragraph in respect of Catherine, the child, In regards to your daughter's school, Medway Council have advised that there are places available in schools local to the property. These schools will give the same level of education your daughter is currently receiving. I say that really doesn't deal with the importance of 11 plus to the family, to the child, and the support that she's receiving from her friends. Over the page, in terms of your support network, you will still be able to contact them via telephone, email, social media, etc. And due to the good transport links from Bexley Borough to the property, you would still be able to visit them and they would be able to visit you. And we say social contact via telephone and email is not the same as face-to-face practical support. She responds. First, to the risk to exposure to COVID, bearing in mind this was in 2020. Secondly, location is very far and out of reach of our friends and family.
I'm sorry, I'm not on the right page now. I'm not on the right page now. Where are you reading?
I'm so sorry, 36.
Thank you.
I beg your pardon. Her response to the 13th of August, really amplifying the reasons she's given before. I take you to Midway. Secondly, the location is very far and out of the reach of our friends and family who usually help me with childcare, shopping and other things, especially during the COVID-19 pandemic. For example, during my recent hospital admission prior to my delivery, my children was taken care of by my family and friends. Looking at the whole scenario, social life would be affected seriously, because it would be hard for friends and family coming all the way from London to offer us help as often as we need will be difficult. And also for me and the children to travel on public, and that will make a struggle. In addition to these, I would not be able to cope without the help from people around me. Clearly English is not her first language, and she was making representations without the assistance of lawyers, but that final sentence is important, I suggest. She says, I will not be able to cope without the help from people around me. My older daughter is preparing for fourth exams, forthcoming. Although there are good schools around there, but it will take her some time to settle in an unfamiliar area, a new school, and making new friends. That will definitely affect her performance in the coming exam. And she's already unhappy hearing the news, moving to an unknown area, losing the bond she has developed with her friends and family. So those are all the matters that were before the authority, before it discharged its duty. And then at 38 onwards, we have a letter sent by email, 1st of September, in support for review, which really amplifies.
Sorry, I wasn't keeping up.
So I'm going a bit fast. Page 38.
38, yes.
There's a letter dated the 1st of September, written by the appellant in support of her review,
Yes.
which essentially makes the same points. At paragraph 4 of that letter, she at page 39, she gives a bit more detail about Catherine, saying she believes the move that far would affect her adversely. Catherine has strong bonds with her friends over here. Since she heard the news of relocating, she has been emotionally down. So, there's also reference by the appellant in their submission to the fact that Catherine had already suffered as all school children suffered in respect to their education due to the lockdown. Notwithstanding that, those representations, no inquiry was made of Catherine's school at all. And this is ground two, but we say that, as my very friend said in his submissions, there is a positive duty to promote the welfare of children. That's not something that needs to be raised, or it has been raised by the applicant. It's something that the local authority must deal with. And here we have a child who in fact is academically gifted, but who's lived in insecure accommodation, I believe, her whole life. I mean, she's been a series of past 7 accommodation. For that, accommodation provided by Children's Services, because the family then was subject to, the appellant was subject to immigration control. And before that, there was a series, I think, of evictions. And she's always been at the same school.
I mean, she obviously wasn't going to be able to stay at the same school. At the end of year 6, she was going to have to move come what may. She could stay for another year. But
Yes. So this is the year when she was preparing for her 11 plus. She was starting 4th September.
I mean, I imagine that the 11 plus would have been that autumn, probably. I don't know what the evidence is, if there is any. But it is supposed to be, in theory, an exam that you can't really prepare for.
Well, my understanding is that the school was preparing her, was intending to prepare her for it in the final year.
This is not probably very relevant at all, but moving to Kent, you again have an 11 plus system, and any primary school presumably would provide a similar sort of training, so far as it's thought to help.
Yes, Bexley, I think, Bexley has the Bexley 11 plus. I really don't know how that differs. But she would lose teachers that she's grown up with, her friends, her support network, her contact. Mother loses her support, and obviously the mental welfare of the mother is a support factor for the daughter. But as we say in the skeleton, we're not saying this is determinative. I mean, if the local authority had made the inquiries it should have done, and I say those inquiries required by Section 11 of Children Act, not cramp-style inquiries, then he could reach an informed decision. They chose not to do so. It simply said, well, there are schools available, and you're not taking or approaching your GCSEs. And both those approaches are wrong. Or, as my little friend says in his skeleton, this is a typical family. I say no family is typical, no child is typical. The local authority is required to investigate and reach an informed decision.
So just to test the limits of that, does the local authority have to go to the schools in every case?
Well, no, I mean, it would depend on the facts of each case. Here you have the mother saying, I have an academically gifted child, education's been disrupted because of COVID, she wants to take the 11 plus, she's been living in insecure accommodation all her life, she's highly dependent on her friends at school, And I believe that a move, particularly shortly before the new school year, would disrupt her education and would affect her emotionally, affect her mental well-being. That's so. With those facts, an assessment needs to be made. In practical terms, the obvious stuff is to speak to the school and see where that takes you, if any further inquiries are needed. So my learned friend took you to most of the provisions in the code, which I would also rely, and of course the law on out-of-borough placement, so I won't repeat that. There are just two sections of the code that he didn't refer you to, which are relevant to my case. So I can ask your lordships, my ladies, to turn to page 50 of the authorities Bible. There's 17.52. When securing accommodation for families with children, housing authorities should be mindful of their duties under Section 11 of the Children Act 2004 to discharge their functions with regard to the need to safeguard and promote the welfare of children. This would include minimising the disruption to the education of children and young people, particularly but not solely at critical points in time, such as leading up to taking GCSE or their equivalent examinations. So that's 17.59 at page 51. The final sentence. For families with school-aged children, the authority should set out how the impact on their education has been assessed and what arrangements have been made for their education in the area of placement. So here, there's simply no evidence at all that the impact of their education has been assessed, other than to say that there are schools available. And then similarly in Solomesco, I have to pronounce that correctly, at tab 20.366, which my friend Mr. Burton, King's Counsel, took you to, there are some passages which deal specifically with the Children Act, which he didn't take you to, which I propose to do so.
Yeah.
The first is at page 377, section heading the children's welfare. And the paragraph 23, Lady Hale says, Section 11 does not define welfare, but Section 10 provides a statutory framework for cooperation between the local authority and relevant agencies with a view to improving the well-being of children in the area. Well-being for this purpose is defined as A, physical, mental and emotional well-being, B, protection from harm and neglect, C, education, training and recreation, D, the contribution made by children to society, and E, social and economic well-being. See section 10.2. The welfare of the child has long been given a broad meaning in family proceedings, encompassing physical, psychological, social, educational, and economic welfare. I pause there. You will have seen from our skeleton that I'll take you to the passage later. In the review decision, the reviewing officer dismisses representations made by the appellant in respect of Catherine's emotional welfare, in the sense that she has the support she gets from her friends at school, by saying, in effect, that's not something we can consider. Well, it clearly is something that should be considered. And then,
could I test test this though?
yes,
The moving of any child from one school to another, from one area to another, is going to have a disruptive effect, both on their education and perhaps on their, in sometimes their emotional well-being. You're saying that because of what Lady Hale says and because of the Children Act, in each case there must be an assessment.
Yeah.
And generally how that's carried out is to, I imagine, is just to say, well, there are schools with places in the other district and nothing more. So are you saying that that in itself is inadequate, or are you focusing solely on this case to say, here we have a child who wanted to take the 6 plus or the 11 plus, etc., and has academic potential, and you should have taken all of these things into account in this case because she is at this juncture in her education and she has these abilities?
Every child's needs should be assessed. It's not, I suggest, enough to say there are other schools available. And particularly the disruption that move will cause. Now, in the facts of this case, I'm not saying that they're extreme at all, but they are, I say, each case is unique. And they require investigation. The local authority may conclude, well, yes, I'm sorry, there will be some disruption, but maybe certain things can be put in place to minimise that. But it has to be assessed, I say.
Could a local authority go to a school, at least without the parents' consent?
I'm so sorry, Marlon.
Would it be open to a local authority when deciding what to do to go to a child's school without the parents' consent?
No, probably not. I've not considered that. But it would be a strange parent who didn't give that consent if they're making these representations. And my ladies, my lord, the other second passage I wish to refer you to in Lady Hale's judgment is at page 378, paragraph 27, which reinforces, I think, the point I'm endeavouring to make. The question of whether the accommodation offered is suitable for the applicant and each member of the household clearly requires the local authority to have regard to the need to safeguard and promote the welfare of any children in their household. Its suitability to meet their needs is a key component in its suitability generally. In my view, it is not enough for the decision maker simply to ask whether any of the children are approaching GCSE or other externally assessed examinations. Disruption to their education and other support networks may be actively harmful to their social and educational development. But the authority also have to have regard to the need to promote as well as to safeguard their welfare. The decision makers should identify the principal needs of the children, both individually and collectively, and have regard to the need to safeguard and promote them when making the decision. And then at halfway down paragraph 30, 379, midway through that paragraph, the local authority may have the ambiguous task of choosing which household with children is to be offered a particular unit of accommodation. This does not absolve the authority from having regard to the need to safeguard and promote the welfare of each individual child in each individual household. And it goes on dealing with policies. So it's clear in my submission that there is a duty to consider and assess the needs of the child or children, identify what their needs are, and then assess suitability having regard to those factors. The mischief in this case is that simply hasn't been done at all. If I may return to the core bundle and the review decision. This is at page 119. The salient points are in our skeleton, so I'm conscious of the time, so I won't take you through this in any detail. But at 127, paragraph 57, is the first time that the local authority says, well, actually, there were two-bedroom properties available within the borough, but they were not deemed suitable for your housing needs, and you offered accommodation at 85 Partington Street. No reason is given, but the assumption is, having seen the assumption is it's because of the allocations policy.
Sorry, assumption is?
The assumption is that the local authority is considering its Part 6 allocations policy.
I see.
Rather than, as we say, should be doing it, the suitability for accommodation in borough on the basis this will be Part 7 accommodation. And then going back one page to page 126, the passage I mentioned earlier, paragraph 52, you submit that your eldest daughter will lose friends from school and you will lose your support network in the Bexley area. I've considered the above submissions, however, I'm not satisfied that this would render the accommodation at 85 Partington Street unsuitable or unreasonable for your occupation. I have arrived at this conclusion for the following reasons. First, it is not feasible for the council to take into consideration your child's bond with her friends at school prior to making an offer, particularly where there is no medical ground for such consideration. And we say that's simply wrong. It's something that needs to be considered because the emotional welfare of the child is just as important as physical education. And then in respect of the practical support that the appellant says she is receiving from friends and church members, that is dismissed in paragraph 53 of midway down, sentencing beginning, you can maintain contact with friends in the usual manner over the phone and on social media. You can also travel occasionally to visit friends and acquaintances, should you wish. And we say that's really an inadequate response to the type of support that the appellant was saying she required at that time.
Just as to Catherine, the officer had also referred to her in paragraph 37.
Yes. And there we see the emphasis to her complaints is, well, there's no medical evidence to support it. And we say that's not an adequate response. So in your request for a review, you advise that you'll be isolated from the support network, and your eldest daughter, who resumed school on the 4th of September 2020, will lose friends, and she's preparing for a 6+ exams. I admit that ideally you would prefer accommodation closer to the child's current school. However, there is no medical requirement to provide you with accommodation that is close to your child's school. And there is no evidence to suggest that the accommodation offered at 85 Hartington Street is unsuitable on medical grounds. Your daughter is not of GCSE age and can access a similar school within the Chatham area. When you raised the argument in protest against the accommodation offered at 85 Hartington Street, this authority took steps to address this concern by contacting Medway Council, requesting information on places available at local schools in the area, and you're given a list of schools and available places which are in close proximity to the property, and satisfy this issue was adequately addressed prior to this authority discharging its duty. For the reasons I've already advanced, we say the issue has not been adequately addressed. All they've done is just see if there are other schools available. It'd be surprising if there weren't. And they're focusing, for whatever reason, on medical grounds in respect of Catherine and or the appellant.
Well, also in respect of Catherine, it's being stated correctly that she's not of GCSE age.
Yeah.
But it's not GCSEs, it's GCSEs or an equivalent examination. And it might be said that the 11+, providing, if it does successfully, a gateway to a grammar school, that is an examination of some considerable importance.
Yes, I respectfully agree. I hesitate to make that submission because one's conscious of the focus tends to be on GCSEs. But Lady Hill makes clear that's not the only. And in fact, Catherine has succeeded and gone to grammar school, yes, and she's hoping to study in Cambridge when she's in due course. So but yes. So those are the, in a nutshell, the submissions on grounds 1 and 2. Now, ground 3 is technical, but in granting permission, Lord Justice Snowden made the observation, page 22, that see round 3, made the observation that the court has recently stressed the requirement for scrupulous compliance with the terms of section 193, which refers to Norton Haringey, which judgment was handed down on the 19th of October last year. It's arguable that this case did not comply with that section, and the point is not covered by authority and has wider potential application for local authorities. So if I may take you once again to the authorities bundle at page 9. Bottom of page 9, section 193(7)AC. For the purposes of this section, an offer is a private rented sexual offer, if A, it is an offer of an assured short-held tenancy made by a private landlord to the applicant in relation to any accommodation which is or may become available for the applicant's occupation. It is made with the approval of the authority in pursuance of arrangements made by the authority with the landlord with a view to bringing the authority's duty under this section to an end. And C, the tenancy being offered is a fixed term with the meaning of Part 1 of the Housing Act 1988 for a period of at least 12 months. So for a local authority to discharge its duty under this section by making by communicating a private rented sector offer, it must be an offer made by an identifiable private landlord to the applicant, not to the authority. And
You say identifiable private landlord. It just says private landlord, doesn't it?
yes, so when I said the applicant should be able to see who the landlord is. So if it's an offer being made by a landlord, it would necessarily be identifiable as individual or corporation to the applicant, not to anyone else. And usually that would be accompanied by a proposed tenancy agreement, one would imagine. In this case, there's numerous references in the letters and emails saying, we will offer you a tenancy. But there's no identifiable landlord, no offer from a private landlord to the applicant, and in fact no tenancy agreement.
So no identifiable landlord, even if one were identifiable, which isn't possible, there's no offer from the landlord.
Exactly.
The last part, tenancy agreement.
No, that's not in.
Depends what you mean by offer, I suppose.
Yes, no, it's not in the section, but that's what one would expect. If a landlord is going to make an offer, they say, well, this is the proposed tenancy agreement. And the local authority's role is to approve the offer, make sure it complies with Article 3, but the various provisions, and that the landlord's a fit and proper person. And really, ground 3 is as simple as that. It's a matter of statutory construction. Which will be quite short. If I may take the court to Norton, it's at page 640 of the article.
So we're on to the additional ground.
No,
Oh, you're still on this.
it's still on ground
I see.
3.
Yes,
It's relevant to both.
yes.
But simply, it's really, I'm just demonstrating where the observation of Lord Justice Stoke came
Yes.
from. So, probably the easiest, the quickest way of doing this is to take the court to page 655, paragraph 58. The judgment of Lord Justice Mayles. In the event, it is clear that the appellant was aware, well within the 2-year period, which is as yet just not yet expired, of the effect of section 195A. Nevertheless, however technical this may be, Parliament has stipulated that if a local authority's housing duty to a person in priority need is to cease by virtue of a PRSO, the offer must comply with sections 193, 78A and 78C. And similar observations were made by Lady Justice Lane. So, although it's technical, that is the correct wording of the reading of the statute in my submission, and the court should follow the approach in Norton and say that strict compliance is necessary. In respect of the proposed additional ground, it's agreed that the offer letter makes the same mistake as the offer letter did in Norton under ground A of the three grounds advanced in that case. That's common ground. My friend accepts that that's a material defect. The mischief that may arise if permission is refused to add the further ground is that if we were to lose the substantive appeal, what one would have would be a lady with her children being made homeless because she would cease to have access to social housing as a result of an unlawful offer. I don't mean unlawful in the sense of, I mean that obviously in the lawyer's sense, that it doesn't comply with the section, and therefore the Court of Appeal has said it's not a proper offer. And that would be, in my submission, wholly unsatisfactory. I accept, of course, it's highly unusual for a point that hasn't been argued below to be advanced on appeal. Of course, I accept all
that's
those
unusual, actually.
No. But with respect to my learned friend, I accept all of that. He cannot reasonably have expected the appellant acting in person to have thought to this point, evaded the housing bar for years until Lucy Johnson thought of it in Norton. And therefore it is a point that's arisen post the review, post the appeal, and post lodging this appeal. Then the last point I would say in respect to that is my own friend in his skeleton argument suggests a possible distinction between the facts of this case and Norton. I can't find this. By saying in effect that the difference is in Norton it's paragraph 63 of his skeleton argument. What he says is in effect in Norton the offer was accepted. In this case it wasn't accepted. If there's any merit in that, then there's maybe an opportunity for this court to make it clear whether that does in fact make any difference. And that may be a point of some importance.
So just, well, I suppose Mr. Let's see to explain why that matters.
Well, with respect to my friend, I don't see it makes any difference. Because if the offer is not a proper offer, it doesn't matter if it's accepted or not. It's not a proper offer. But he seeks to make that distinction. As I say, I fully appreciate how unusual this is, but I would be betting in my duty but not to raise it in the circumstances. So, my lord.
What I might just say to alert Mr. Calzavaro to a point is he stresses the second appeals test. I have to say my current understanding, until I'm put right, is that once an appeal is through the gateway, it is not the case that every ground of appeal has to satisfy the second appeals test. If the appeal overall satisfies the second appeals test, you can have individual grounds that don't. So I'll leave Mr. Calzavaro to think about that and persuade me otherwise tomorrow.
I'm grateful. My lords, my ladies, unless I can assist any further, there's my answer.
Thank you very much. Mr. Grundy.
My lords, my lady, I'm going to deal with the submissions made on behalf of Miss Zaman in this way. I'm going to try and establish what the in-borough and out-of-borough duties are, because my learned friend has alternatively put them as you have to, or we accept that there is no dispute that the in-borough duty is so far as reasonably practical, and that remains. But that isn't how Baroness Hale puts the as close to borough as possible duty, and my learned friend variously referred to it as reasonably practicable, reasonable, etc., etc. I'm then going to deal with the allocations policies and the procurement policy and the allocation policy in that order, because in my submission that's the order in which they should be approached. Procurement as a matter of logic coming before allocation. My learned friend says, and I'm grateful for this, that the procurement policy is not unlawful of itself. What they challenge is whether or not it was followed. They say there's no evidence to support the proposition that it was followed. So I will start, my lord, my ladies, in the authorities bundle, tab 20, Nosolomezo, paragraph 19, which is on page 376 of your authorities bundle. Part of the ratio that I'm going to read to you in a moment is derived from the code of guidance that was then in force in 2015 and had been in force since 2012, November 2012. And you'll see that's at paragraph 18 of the judgment above. The code of guidance was changed when the Act was amended, I apologise, the supplementary guidance was issued when the Housing Act 1996, section 193 was amended to allow local authorities to rely on private rented sector offers to cause their housing duty to cease. I'm not going to use the word discharge because it's in my submission it has two potential meanings. Discharge could mean I am continuing to perform the duty, or that I have caused it to come to an end. The Act uses the word causing the duty to cease, and in my submission it is important that we are precise about that. So paragraph, you'll see there, paragraph 18, Baroness Hale sets out paragraphs 48 and 49 of the supplementary guidance. So that was part of the material that she relied upon to come to her expression of what the in-borough and as close to borough duties are. Paragraph 19. The effect, therefore, is that local authorities have a statutory duty to accommodate within their area so far as this is reasonably practical. Reasonably practical imports a stronger duty than simply being reasonable. But if it's not reasonably practical to accommodate in borough, they must generally and where possible try to place the household as close as possible to where they were previously living. So it's not reasonably practicable. It's generally and where possible. Now we will come to why that is the case in a moment. But if you turn over the page, back to page 376, and paragraph 48 of the supplemental guidance.
Sorry, give me the reference again.
Paragraph 48 of supplemental guidance, it's in paragraph 18 of Baroness Hale's judgment, and she quotes it, or she sets it out in full. And you'll see she says, that guidance said, where it is not possible to secure accommodation within the district and an authority has secured accommodation outside their district, the authority is required to take into account the distance of that accommodation from the district of the authority. Where accommodation which is otherwise suitable and affordable is available nearer to the authority's district than the accommodation which it has secured, the accommodation which it has secured is not likely to be suitable unless the authority has a justifiable reason or the applicant has specified a preference. And you can see there the context in which as close as possible comes, because if there was something closer, what we've given you is unlikely to be suitable. If we go back, possibly...
I mean, the paragraph 49 is the source of Baroness Hale's particular phrase, isn't it?
Yes. It's easiest if I explain this by reference to the June 2020 iteration of the 2018 code that you have in your bundle. I'm not sure why you've got the 2020 iteration. I understand that's what it is. In the respondent skeleton argument, we refer to slightly different paragraph numbers because the Home Secretary has seen fit to produce a number of different iterations of the 2018 code. I did bring along a sheet setting out all of the changes over the years, but you probably don't need to see that.
Speaking for myself, I wouldn't mind having it so that we're exactly clear what's gone on.
When I say I've brought a sheet setting out all the changes, that's not right. What I've set out has the dates of the different iterations and the paragraphs that were amended.
Thank you very much.
I don't think for our purposes you need to know what the changes were.
Yeah.
But you'll see that since they go down in chronological order from the top, and you'll see since the 2018 code was introduced in November 2018, there have been about 12 changes, 12 new variations. You have the June 2020 iteration, as I understand it, which is the 6th version number down the page. For these purposes, I don't think there have been changes to the code that are material. In effect, what I'm going to take you to, the text of it remains the same throughout the period that we're concerned with. So page 49 in your authorities bundle, my lord, my ladies, has a heading a third of the way down the page, location of accommodation. And this is in the Code of Guidance. Before I take you through it, I'll just point out that there's a hierarchy here. The hierarchy of derivation of what is being said. So paragraph 17.47 at the top of the hierarchy deals with the Act. Paragraph 17.48 deals with the Newey guidance on policies. And then at the bottom we get towards the 2012 order, Article 2. What I want to take you to, my lord, my ladies, is paragraph 17.49, which is a repeat of paragraph 48 of the Supplemental Code of Guidance. Except that it has the last clause of the last sentence as an addition. So if I read you the second sentence, which starts 4 lines down from the top in the middle, where accommodation which is otherwise suitable and affordable is available nearer to the authority's district than the accommodation which it has secured, the accommodation which it has secured is not likely to be suitable unless the applicant has specified a preference, the additional words, or the accommodation has been offered in accordance with a published policy which provides a fair and reasonable allocation of accommodation that is or may become available to applicants. So if Baroness Hale was now deciding the Zolomezo, the Code of Guidance wouldn't say the accommodation has to be as close as possible to the borough until you get to paragraph 17.50, which is down in the hierarchy. It must be, in my submission, read after 17.49. Because otherwise, if there was accommodation that was available that was closer to the borough, there would be a contradiction between 17.50 and 17.49.
I mean, one might possibly, spelling it slightly differently, hope to arrive at a reconciliation of the two.
Well, the reconciliation really is because if you read 17.50, 17.50 has a purpose. And the purpose is not to destroy current established links. And that is taken from the 2012 order, Article 2, which I'll just take you to once we've had a look at that. But effectively, it's a repeat of the purpose of the 2012 order, Article 2. So generally, where possible, housing authorities should try to secure accommodations as close as possible to where an applicant was previously living. Note, it doesn't say within your borough, it says to where they were previously living. It's always said that. Even in the supplemental guidance, it said that. Securing accommodation for an applicant in a different location can cause difficulties for some applicants. Where possible, the authority should seek to retain established links with schools, doctors, social workers and other key services and support. So you can see that the purpose of trying to house people as close as possible to where they were previously living was to retain those links. If you turn back to page 37, tab 5 in the authorities bundle, which is the 2012 order, Article 2. You will see that Article 2, B, refers to the significance of any disruption which would be caused by the location of the accommodation to the employment, caring responsibilities or education of the personal members of the person's household. In effect, if and insofar as you can, generally try not to break those links. So we could now look usefully.
Of course, A has specifically said that you have to have regard to
The distance. Yes. So if we now have a look at the policies under attack, I'm going to start with the procurement policy because in my submission that's a very good place to start, because in my submission you procure things before you allocate them. You can't allocate what you haven't got. Apologise, I just need to find my note. So, if you look at under the heading Key Principles on page 11
Of?
Sorry, I apologise. The supplement. I'm now in the. So both policies are in the supplemental bundle. They're not in the order in which I'm going to deal with them. They're in the opposite order. The one I'm going to deal with them. The acquisitions policy, or procurement policy, as I've been calling it, comes second, starting on page 11. The approach of the service to the acquisition of properties is informed by the following key principles. Tab 1, bullet point 2. Where possible, these units will be in the borough, Zone A. However, the service may acquire properties in a range of other locations where it appears that supply of the units in the borough will not be sufficient for the anticipated demand. Can I say, as Lord Justice Lewison says in Alibkiet, you'd have to be a hermit not to know that there wasn't a severe housing crisis in London and the South East. I may have paraphrased that a bit. Bullet point 2. In addressing the bullet point 4 at the bottom, I apologise. In addressing the shortfall, the service will endeavour to acquire units in locations which are close to Waltham Forest in order to minimise, as far as possible, the distance between the borough itself and the location of accommodation being offered to households who cannot be accommodated in the borough. These nearby locations are, and then we see the definition of Zone B. So we've got definition of Zone A in bullet point 2, and the definition of Zone B in bullet point 4. Turn over the page, my lords, my ladies, to page 12. Top bullet point. So this continues to be part of the same key principles. Where the demand for accommodation is such that it's unlikely to be possible to acquire sufficient properties for all homeless households in Waltham Forest and in nearby locations, so Zone A or Zone B, the service may acquire properties in other locations, Zone C, which can be offered to homeless households applying the approach set out in the temporary accommodation and private rented sector offer policies. So this is referring to the allocation policy. Now what we have there in terms of Zone A, B and C is effectively a practical demonstration of the duties. The first duty is in borough, as far as reasonably practicable. The next is, if not reasonably practicable, generally to try to secure accommodation as close as possible. Zone B, to avoid the breaking of the ties that bind us, the support networks, etc. And then we've got Zone C. In relation to Zone C, under the heading Anticipated Demand for Accommodation, the acquisition policy says on page 12 at paragraph 4.3, on this basis, the acquisitions policy assumes that it will be necessary to secure properties in a range of locations beyond the borough itself and nearby locations. All properties procured under the policy will be as close to the borough as is reasonably practicable, given the financial constraints within which the service operates and the practical difficulties which can prevent units being procured in borough or nearby locations. So there you are, we've got the as close as possible element.
So just help me. Do you accept that that approach is what is required by the legislation and guidance?
I don't. I think that goes beyond what is required by the legislation, because in my submission now, if you allocate accommodation in accordance with a policy that provides for allocation of accommodation on the basis of need, it doesn't have to be as close as possible.
So it would be open to a local authority in London to say property is very cheap in Land's End. We will only offer property in Land's End by way of Zone C properties.
If it would be open to a local, authority if it allocated property in accordance with an allocations policy.
I mean,
that
if they
provided for
set
need.
out in their allocations policy by way of, if we can't allocate in borough or near borough, we will allocate exclusively in Land's End.
Well, in my submission, that would probably be unreasonable
Because
of the availability of property in Land's End. I mean,
actually,
they have to use their they have to, using their resources, source accommodation where it is most reasonable to source it.
Penzance. It's all in Penzance.
All in Penzance. I would submit that that would comply with the current legislation. Yes. But if I am wrong about that, this policy, in any event, says that what we are going to procure will be as close to the borough as is reasonably practical, given the financial constraints which the service operates. So in my submission, my learned friend accepts that the policy was lawful. And in my submission, if in a case such as this, evidence is required that that has been being done, that goes beyond what Baroness Hale provided the guidance or the policies would achieve in the Zolomezo.
And I follow that may be at the heart of all this, but just pausing for a moment, in terms of financial constraints, where you're dealing with PRSOs, if the applicants can afford the rent, there's no financial burden on the local authority.
That's not right. The local authority still has to find the accommodation. So we're talking about a local authority not looking in its own borough anymore. We're talking about a local authority looking for accommodation outside its borough.
But it must be just as cheap to look for property in Peterborough as it is to look for property in Stoke, presumably.
Well, my recollection from Alib Kiet was that London Borough of Brent had people on the ground in the relevant areas.
But you can choose an area, and there's no particular reason to think that it's cheaper to choose Stoke.
Well, I think the amount of local authority... Sorry. If it is right, perhaps I can answer it in this way. If it is right that you have to look in circles of increasing distance away from the local authority to try and find the accommodation, that is going to get more expensive. Because you then have to you look in one area and then beyond it and then beyond it and then beyond it. It might within
So
your...
it would be the multiple zone concept that would be more expensive.
No. Looking in the major conurbations makes sense, financial sense.
Actually, I'm
Yeah.
sorry, we do have to break, but
I've
Stoke
come
isn't that big a conurbation. They're a much bigger conurbation.
There are. Yeah. But there's no... I mean, what's being suggested is there's an absence of evidence that you looked elsewhere in this individual case, therefore you weren't looking anywhere else. I mean, it's the kind of... my individual circumstances illustrate that you're not complying with your policy.
We better leave it there. But we'll start again at 10:15 in the morning.
My lord, yes.
Right.